So, Tom, when you're dealing with protest cases in the criminal court, how does the right of freedom of expression get taken into account?
That's a really good question because it's changed comparatively recently. So in 2005, there was a case in the High Court called De Haal, and what the court said in that case was that in order to make sure that Article 10 and the right to freedom of expression is taken into account in a criminal case, even after the prosecution have proved all the other elements, the court still has to take a step back and decide whether or not the prosecution itself is a proportionate response to the protest. And so decide whether or not, for example, there was an ongoing problem, if the behaviour had been repeated, and things which factor into the public interest in prosecuting a case. And that approach held sway for quite some time, and it gradually got chipped away at until in 2015 there was a case by the name of James versus the DPP, in which the High Court said that De Haal was wrong and shouldn't be followed anymore. And what they've said instead is that in order to make sure that Article 10 is taken into account in a criminal case, then the courts have to factor it into the elements of the offence themselves. So, for example, it's easiest when dealing with offences under the Public Order Act for threatening, abusive or insulting words or behaviour and that sort of thing, Section 4, Section 5. Because when the court's deciding whether or not something amounts to insulting or threatening, then they have to factor in the importance of freedom of expression. And there's lots of important European case law as to when it does cross the line from freedom of expression into criminal offending, and lots of helpful guidance from the courts. So, for example, it's been said that freedom of speech includes not only the inoffensive, but also the irritating, the contentious, the eccentric, the critical, and the provocative, provided that it doesn't tend to provoke violence. And they say that freedom to speak only inoffensively is a freedom not worth having. So that's quite an easy way that the courts can look at Article 10 in the context of the criminal case itself. In James, that was a case concerning Section 14 of the Public Order Act, and so conditions being imposed on a protest, and the court said that the Article 10 rights would be taken into account because the officer would have to have reasonable grounds for believing that the assembly in question may result in serious disorder, and that the conditions must genuinely and reasonably appear necessary to the officer in order to prevent that serious disorder. And that's the place where Article 10 can be factored in Section 14, and it would also apply to Section 12 cases, conditions imposed on marchers. But as far as other cases are concerned, and other offences which may feature in protest cases, the position isn't so clear. There's the Supreme Court case of Richardson, which dealt with aggravated trespass, where the court's view was that once a trespass was carried out, there was no more room for Article 10. I think that's open to challenge potentially in the right case, looking at more of the European case law. But there are other cases where it's simply not been considered. So, for example, offences of watching and besetting, and particularly offences which may be committed under the bylaws. So there are some locations where it's a offence contrary to the bylaw to hold up a notice without permission. And I think that's another sort of area where it's right for challenge, and the court's going to have to deal with the relationship between the criminal law and Article 10 and the right to freedom of expression.
Right, fantastic. And do you think it's something that judges themselves are well aware of, or is it something that you as barristers with your client support need to teach them about?
I don't think it's something that judges are aware of, because judges will normally look at the offences it's set out in the regular practitioner texts, which set out the elements of the offence and nothing else. And because the approach has to be different in protest cases, and because that can cover such a wide variety of offences, and because there isn't settled case law on each and every offence, then it's something that practitioners dealing with protest cases really need to be alert to and need to raise in their submissions, both at the close of the prosecution case potentially, and certainly in their closing submissions to the tribunals.
That's really helpful, Tom. Thank you very much.